In 1951, the New York State Board of Regents, or the State Board of Education, approved a prayer for recitation each morning in the public schools of New York. This non-denominational prayer read,
Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen.
The prayer was offered for use to all of the public schools in the state, although participation in the school-led prayer was voluntary. In New Hyde Park, New York, the Union Free School District Number 9 directed the local principal to have the prayer said aloud by each class in the presence of a teacher at the beginning of the school day. School board officials of the district decided that they were not violating individual rights because they included a provision in which a parent's signature could excuse a child from reciting the prayer. The parents of 10 pupils in the New Hyde Park schools of New York objected to the prayer. They filed suit in a New York state court seeking a ban on the prayer, and they insisted that the use of this official prayer in the public schools was contrary to their own and to their children's religious beliefs and practices. These parents contended that the practice violated the religion clauses of the First Amendment, which read, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. One of these parents, a Jewish man by the name of Stephen Engel, claimed that alphabetical order thrust his name into the position of lead plaintiff in the case. The state appeals court upheld the use of prayer, so long as the schools did not compel any pupil to join in the prayer over his or his parents' objection. The governments of 22 states, as well as the American Ethnical Union and the American Jewish Committee and the Synagogue Council of America, signed briefs urging the Supreme Court to review and reverse the decision of the State Court of Appeals.
Justice Hugo Black presiding. We will begin today, April 3rd, 1962, by hearing from the plaintiffs on 370 versus 421, Engel versus Vitale. Plaintiff.
Court and Justices, these 10 families are here because such a prayer violates the Establishment Clause of the First Amendment of the United States Constitution, which says, in part, Congress shall make no law respecting an establishment of religion. We have an amicus curiae briefing urging the affirmation of the New York Court of Appeals decision signed by the governments of 22 states. As well, the American Ethnical Union, the American Jewish Committee, and the Synagogue Council of America have each submitted briefs urging the court to reverse and rule that the prayer is unconstitutional. No child should be required to say a prayer, especially one not of their faith or religion. We instead advise that New York District Number 9 gives a silent period for each child to pray, mediate, or sit silently.
New York District Number 9 did not establish a religion by providing a prayer for those who wanted to say it. Countless religious elements are associated with governments and officials, reflecting the religious heritage of the nation. New York acted properly and constitutionally in providing an optional, non-sectarian prayer. It would be an intrusion onto state matters for the Supreme Court to strike down the right of school districts to compose the prayer and encourage its recitation.
As a 6-1 decision, the Supreme Court finds the New York District prayer to be unconstitutional. We believe that by using its public school system to encourage recitations, that district prayer, the state of New York has adopted a practice wholly inconsistent with the Establishment Clause. There can, of course, be no doubt that the New York's program daily classroom invocation of God's blessing in the district prayer is a religious activity. The Establishment Clause thus stands as an expression of principle on the part of the founders of our Constitution. That religion is too personal, too sacred, too holy to permit its hallowed provisions by a civil magistrate. In the words of James Madison, one of the founders of our Constitution, the author of the First Amendment, who does not see that the same authority which can establish Christianity in exclusion of all other religions may establish with the same ease any particular sect of Christians, in exclusion of all other sects.
In 1962, the Supreme Court held that the entire idea of a state-mandated or state-sponsored prayer violated the Establishment Clause of the First Amendment. As Justice Hugo Black noted, the state violated the Establishment Clause by promoting any kind of prayer or other religious activity. The only dissenting opinion was that of Justice Potter Stewart. Stewart noted early examples of religion in government, such as presidents asking for God's protection in their inaugural addresses and the phrase, "In God We Trust," on coins. Stewart held that allowing students to pray in school-wide manner did not necessarily suggest an establishment of religion. And the decision in favor of the plaintiff, Stephen Engel, provoked much criticism toward the Supreme Court. Many U.S. citizens believe that religion should be fostered by the state, and that while no particular doctrine, religion, or church should be established, the state should equally support and promote all religions. These people also believe that praying in schools is a natural and historic tradition in a country that claims to be one nation under God.